result that they're looking for, and it will just lead to further re-traumatization through the trial process and through the court system, especially for something like coercive control, where they will likely be forced to kind of rehash all the experiences of their life and the ways that it impacted them. And
Il reste quelques secondes, Madame Parsa, s'il vous plaît.
There are just a few seconds left, Ms. Parsa. Sorry for interrupting you. Could you tell me just in a few words, how can we explain that some victim protection groups are asking us to adopt 332? How do you explain the difference of opinions between what various witnesses are saying?
I mean, I think that's a difficult question. I certainly understand groups who are advocating in support of this. I think that our experience is based on research and kind of a wider lens of how these laws have been used to.
Thank you very much for that. I
Merci.
will now go to Madame Baron for the last 6 minutes.
Thank you, Chair. I'm happy to be here today covering for my colleague, MP Garrison. And I want to thank the witnesses for bringing further information. There's a lot of important additional context to this discussion that I've heard today. My first question is to Ms. Mathieu. Ms. Mathieu, can you expand a little bit further on, you were discussing the marginalized and racialized people, the additional barriers that are faced, and the lack of trust in the legal system as one example of the barriers that are being faced. I'm wondering, I want to make sure that this is very clear and recorded. Can you expand on that a little bit and provide perhaps a couple of examples further
Absolutely.
than what you have?
Yes, thank you. In terms of the barriers that racialized and marginalized communities experience, especially the ones who don't speak our official languages and require interpreters and language access in bringing forward their challenges to the legal system, they have a lot of lack of trust on the system because how they are treated in the system routinely. Ms. Parsa just a few minutes back talked about the low conviction rates of a lot of these cases that come forward in the system and the traumatization of the survivors. Traumatization of the survivors who experience inherent bias in the system is even more. They face that whenever they are coming forward, they are not necessarily trusted. They find themselves charged, and that's like one of the historical changes in the criminal code that we are still seeing the repercussions of, and we haven't really found the solution for it. And I just very quickly in closing to this question want to say that I think it is incorrect for us to create a dichotomy between whether this is to support survivor or whether it is not to support survivors. I think the challenge lies somewhere in between, which is that system is not working and the system needs fixing before we go on to bring more charges on the books or more criminal code changes, because on the surface they look really good, but unfortunately they become window dressing. And I have been in front of you and on your colleagues in past, many years ago, talking the same thing about the forced marriage cases and said that don't criminalize it because it will put the issue under the rugs. And it did put the issue under the rugs. And I don't want coercive control, which has made a lot of progress in our jurisprudence. And the judges are understanding. In the family law context, there are cases where judges are understanding in a much better way. And I don't want that the coercive control again becomes another action that goes under the rugs. People stop talking about it because it's so hard to prove.
Thank you. I think I might move to a different part of my questions that I wanted to ask you based on your response. I did hear Ms. Parsa talking about the conviction rates, and I'm wondering if you can perhaps talk a little bit more around the reporting rates and what you think, just expand a little bit more on how you feel that relates to this bill, and if you feel that we would see an increase of women reporting abuse as a result of a tool being brought forward to be able to do so.
I, from my personal experience, doubt it because I have seen what has happened with the FGM and forced marriages. I don't necessarily believe that there will be increase in the reporting rate, but going by the experience of England and Wales, where there was increase in the reporting rate, I want to highlight that only 6% of the charges brought forward actually saw a prosecution. So it is not necessarily that the reporting rate would mean that there will be more people made accountable. And that unless and until we balance that accountability, I think the purpose and the ethos of the criminal justice system is not met.
Thank you. With the reporting, though, and I do recognize there's a low reporting rate, there's a low conviction rate, but would the reporting in itself provide opportunities to look at other supports, so looking at different forms of moving forward with a more what's the word, restorative process, looking at increasing supports, looking at getting the pattern of abuse documented. What are your thoughts on perhaps the benefits of seeing an increase of reporting that may result from this tool?
Unfortunately, I think increase in reporting without really a proper solution offered, and we don't have those mechanisms, right? Like the restorative justice system and transformative justice system, and I also want to highlight that if we come to those solutions, there will be further discussions and further advisory needed and further conversations needed. So because we don't have that in the system in existence right now, hence we have the reservation, right? So I work with the organization which serves 14,000 people who survive violence every year. So I should be the first one saying, yes, please bring on another tool. My challenge is that I provide those services in an environment where the environment is really broken for the most marginalized. People from immigrant communities and non-status communities don't even want to come forward and report the crimes for the fear of the deportation, for the fear of further repercussions. So in that environment, I find it really difficult to support the idea to create another law without the supports available.
Thank you for the additional information. What I'm trying to navigate, because I do agree, there are many, with much of what you're saying, I do agree that there are serious problems in our justice system. I do agree that we need to be looking at this through a systemic lens, that there are serious issues in the supports.
Thank you, Ms. Baron.
I'll end there, but I appreciate your comments. Thank you.
So we have a few minutes left. I'm trying to maneuver our time. So perhaps what I'll do is I'll cut in half. And I'll go to Mr. Van Popta perhaps for 2.5 minutes.
Good. We'll do our best with 2.5 minutes. This question will be for Ms. Parsa. We heard from you and Ms. Matu as well, and other witnesses earlier in the study that Bill C-332 is not the answer, and we recognize that fully. It's just another tool. We're saying, and we're being told, and we've heard from you as well, that education is more important. Training for police, education for Crown prosecutors, enhanced court worker programs is what we heard from earlier witnesses. But aren't we creating a false dichotomy between law and education? Like, why can't they both be done? Why is one mutually exclusive to the other? And so, Ms. Parsa, I have a great quote from you. In your submission, it says, the expressive power of law may also send a message of condemnation of this form of violence to society. I fully agree with that. The law itself can be educational.
I think you're speaking from our written brief, and I think that I do agree with that in certain situations, and I think that is kind of one of the benefits that is being put out as a reason for criminalizing. However, in our brief, as we say, we do not think that these benefits outshine the many, many risks that are being posed by creating a new criminal law. I also think that I understand your question about, why is this a dichotomy? I actually think the question should be, why does training only exist when there is a new law? What we're advocating for is increased training around coercive control within the current system so that police, law enforcement, justice system actors become aware of the complexities of what this abuse looks like. You don't need a law to kind of gain a deeper understanding of intimate partner violence. And in addition to training, I think there should be more public awareness campaigns as well, so that women and survivors are also aware of situations of coercive control and can begin to kind of think about their own experiences through that lens. And so the criminal law, while some may say it has an expressive power, and it certainly can in situations, that doesn't outweigh kind of the many risks that I've written about in that brief as well, and that we've been talking about.
Thank you. I think that's all the time we have.
Thank you very much. Madame Dillon, 2.5 minutes.
Thank you, Madam Chair. I've been very carefully listening to the witnesses, if either one cares to answer. Do you not think that having this kind of mechanism in the law would allow those who are voiceless to step forward if it's their choice to come and report such abuse uh, being perpetrated on them? Um, does it not at least give them that option, that choice to raise a voice against this? I mean, not having anything at all uh, is more harmful than being able to have a mechanism that allows you to uh, express such insidious abuse. And we've heard other witnesses even talking about how pets are being used in this type of abuse. Do you not think it's important that a person who is going through this be able to come forward if that's their choice and have themselves protected in some way? Thank you.
I can take on Roxana, and I'll pass it on to you if I have time left. I just want to say that I don't think me or Roxana or others who are talking about the systemic challenges currently, which doesn't allow survivors to come forward safely, are talking about that survivors shouldn't have a choice. We work from a trauma-centric, survivor-centric way, and we definitely believe that the survivors should have all the choices and all the options. They should have buffet of options to choose from in terms of what actions they want to take. Unfortunately, honorable member, what I am trying to talk about is that when they make those choices, they are in an environment where there are risks associated with those choices. The studies tell us that number of women who come forward are at much higher risk of lethality as compared to the women who don't interact with the system. So when you have a system which is so broken, which doesn't do risk assessment of their situations properly, which doesn't provide them the support in coming forward, creating another criminal code change and making it making another criminal law change and bringing forward a crime of course of control can potentially create a window dressing and potentially create more harm and re-traumatize survivors because they will come forward. There will be no action taken. They will be putting themselves at risk with no recourse available to them. And that's where our fear is with this change.
But do they not put themselves at risk in any other law that helps to protect women who are victims of intimate partner violence? Anytime they step forward, there's always a risk. Do you not believe that that is the case? If anyone can quickly answer, do I have time?
I'm afraid, although I would encourage the witnesses, based on the questions you're receiving, if there's anything that you believe needs to be clarified or further added, to please send the committee something in writing. Maybe what I'll do, for fairness, I'll give Monsieur Fortin seulement une minute s'il y a quelque chose.
Mr. Fortin, I'll give you just 1 minute if there's something that you really want to ask. Otherwise, well, in 1 minute. My colleague found it difficult to do it in 2.5 minutes, but I will be satisfied myself by saying that I appreciate the amendments such as that we have in Brooks Place's amendments that are supported by Ms. Barbara Schlifer. It's useful. I am skeptical about the idea of just providing training, but I'm convinced we have to give training and raise the consciousness in the population. So I think it's important to pass through those steps. But I will read your brief very carefully and maybe find good ideas to improve SC 332. Thank you. Thank you, Mr. Fortin.
Spadon.
Be clear to ask a question, right? Okay, thank you. My question, Ms. Parsa, just quickly, if you can clarify, you had said that, I don't remember the exact wording, but basically you had said that there's increased risk of misinterpretation to see abuse when non-existent. Can you please clarify what you meant by that comment and provide an example? That would be helpful for me. Thank you.
Sure. So I think I was speaking kind of related to